Hi, my name is Robert Chelle with Chelle Law, and my law firm assists physician assistants with employment contract issues. Today I'm going to talk about whether a W-2 or 1099 is better for a physician assistant. So, if you're working as an employee for a private practice or a hospital, you're going to be classified as a W-2 employee, meaning you'll receive a W-2 at the end of the year, and then taxes will be withheld from whatever your regularly paid compensation is. If you're working as an independent contractor, you're going to receive a 1099 at the end of the year, and no taxes are going to be withheld from any compensation you receive from whatever organization that you're working for. So the main differences between the two of them is 1099, no taxes are withheld, W-2, taxes are. Additionally, if you're working as an employee, you're going to receive all of the good benefits that a normal employee would. So most likely health, vision, dental, retirement, life, disability. They're going to pay for your board license, DEA registration, continuing education. You're going to get paid time off. All of that in a normal employment relationship would be covered by the employer. If you're working as a 1099, you're going to be responsible for all of that, including malpractice insurance. Now, if you want to maximize your tax deductions, then what you should do is create an LLC, get an EIN, get a bank account in the state that you're working in, and then put all compensation and expenses, have it flow through that bank account. That way you can, track whatever your expenses and revenues are, and then use that as tax deductions at the end of the year as business expenses. I would suggest if you're going to work as an independent contractor, you should talk to an accountant in advance of starting or signing the agreement, and then setting up all of those things properly so you can maximize your tax deductions. If you do set up an LLC, you don't have to do it for every single job that you take as an independent contractor. So it's good to go from when you start until however long you want to work as an independent contractor, for multiple different organizations. What they would do is they would just have in the independent contractor agreement, it'll state who the parties are. Just use the contract is they're contracting with your LLC and not you personally, and that way the relationship is set up correctly. Now, as I said before, situation really dictates which one is better. There are times where an employer will ask you to work as an independent contractor, but they're really treating you as an employee completely. The reason why most of them would do that is just to save paying employment taxes, which is usually around 10 to 12% of your total compensation. So the IRS lists kind of like a 20-factor test to determine whether someone is an independent contractor versus an employee. I would suggest if you're concerned you're being misclassified, that you look at that test, and then if it's clear you're actually an employee, but they're just classifying you as an independent contractor so they don't have to pay for employment taxes or give you any benefits, bring that to the attention of the employer and say, look, I believe you're misclassifying me. I'm not comfortable signing this. I mean, what could happen is if the IRS determines that you were misclassified, they could come back at the employer for employment taxes. Sometimes employers will even put language in there stating that the independent contractor would be responsible if the IRS comes back and says they were misclassified for those back taxes and penalties. Absolutely do not sign something that says that. So that's kind of the different scenarios where it might make sense to be a W-2 versus a 1099. Just depends upon the situation. I mean, most people, if they're just working sporadically, maybe once or twice a month for a surgeon or something that you're assisting in, like if you're in orthopedics or something like that, that makes sense to be an independent contractor. If you're working every single day, 9 to 5, you are not an independent contractor. It's just it's very, very unlikely a scenario like that would dictate you be classified as an independent contractor. So you just need to be careful. If you have any questions about your employment agreement or independent contractor agreement, please feel free to contact my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. If you thought this video was helpful, please like, subscribe to the channel. We release videos every single day. Appreciate you watching the video. Thanks.